Welcome to the Georgia Real Estate Exam Prep course. This module introduces the Georgia Real Estate Commission standards and the core competencies you must master to pass your licensing exam. This content is for informational and entertainment purposes only and does not constitute legal advice. This is an unofficial, independently produced course and is not affiliated with, endorsed by, or connected to the Georgia Real Estate Commission or any official exam testing provider. Always consult a qualified professional before making legal or career-related decisions. Passing the Georgia Real Estate Licensing Exam is a significant milestone that requires more than just general knowledge. By choosing this course, you are positioning yourself to understand the specific legal framework and professional standards required by the Georgia Real Estate Commission. We will break down the complex requirements into manageable sections, ensuring your preparation is both strategic and efficient. You will gain clarity on exam formatting, testing procedures, and the specific state-level nuances that often trip up unprepared candidates. This is your comprehensive roadmap to achieving that passing score and launching your professional career. The Georgia Real Estate Exam is structured to test your knowledge of both national concepts and, more importantly, Georgia-specific legal requirements. Understanding the exam format is your first line of defense. You will face a total of 152 questions, and the distribution is heavily weighted towards state-specific laws and the Brokerage Relationships in Real Estate Transactions Act, commonly known as BRRETA. We will spend considerable time dissecting the candidate handbook, which serves as your primary guide for testing center protocols and passing criteria. Many students fail because they rely on generalized national real estate principles rather than the specific statutory language used in Georgia. You must reconcile your understanding of property law with the unique regulatory environment established by the Commission. Mastering these distinctions will save you time and prevent errors during the high-pressure environment of the actual examination. Effective preparation depends on a rigorous study plan that balances legal theory with practical application, specifically regarding agency relationships and state-mandated codes of conduct. We will examine the professional standards required for those entering the industry under a sponsoring brokerage, focusing on the duties you will owe to your future clients and customers. The course will guide you through the intricacies of license law and the expectations of the regulatory body, which are non-negotiable for anyone seeking to hold a license in the state. We will also address exam day logistics, such as which calculator you are permitted to bring and how to manage your time across the different sections. By establishing a disciplined routine now, you will build the stamina required to maintain accuracy during your final assessment. This preparation goes beyond rote memorization. It is about building a structural understanding of how business is conducted legally within our local market. I look forward to walking through these concepts with you. Welcome to this deep dive into the regulatory heart of Georgia real estate practice. In this session, we will examine the Georgia Real Estate Commission and the mechanisms that govern licensee conduct across the state. The Georgia Real Estate Commission is the primary authority responsible for supervising the activities of real estate licensees to ensure the protection of the public interest. The Commission consists of 6 members appointed by the Governor and confirmed by the Senate, each serving a 5-year term to ensure continuity and stability in regulation. These members are tasked with the critical responsibility of creating and enforcing the rules that dictate how brokerage activities must be conducted. While the Commission does not act as a judicial body in a general legal sense, it wields significant administrative authority to perform investigations into alleged violations of license law. Understanding the scope of this authority is essential for any licensee, as it defines the boundaries of professional conduct. The Commission performs its duties through rulemaking, which allows it to adapt to changing market conditions while maintaining a baseline of ethical and procedural compliance. By upholding these standards, the Commission effectively acts as the guardian of consumer trust within the Georgia marketplace. when a complaint is filed against a licensee, or if the Commission identifies a potential violation through its own oversight processes, it initiates an investigative procedure governed by the Georgia Administrative Procedure Act. This act ensures that the licensee is afforded due process, which includes the right to formal notification of the charges and the opportunity to present a defense during a hearing. Investigators have the power to examine brokerage records, interview involved parties, and collect evidence to determine if a violation of license law or commission rules has occurred. If evidence supports a finding of wrongdoing, the case may proceed to a disciplinary hearing where an administrative law judge or the commission itself weighs the facts. This procedural rigidity is designed to prevent arbitrary enforcement and to guarantee that every licensee is treated fairly under the law. It is important to realize that the Commission prioritizes fact-finding, and any attempt to impede an investigation can, in itself, lead to additional sanctions against the licensee. The potential penalties for violating license law are structured to serve both as a deterrent and as a corrective measure for professional conduct. Depending on the severity of the violation, the Commission may issue a reprimand, impose a fine, or move to censure, suspend, or permanently revoke a license. Fines are often utilized for administrative or procedural lapses, whereas license revocation is reserved for egregious acts that demonstrate a fundamental disregard for public welfare or ethical standards. For instance, a broker who fails to maintain proper documentation might face significant fines and mandatory educational requirements, while a licensee involved in fraud or conversion of funds will almost certainly face catastrophic career consequences. Additionally, the Commission may require a licensee to complete specific coursework or be subject to a period of strict probation. These disciplinary actions are matters of public record and are intended to demonstrate the Commission's commitment to holding professionals accountable. Because the public is not always protected by a licensee's professional liability insurance, the Georgia Real Estate Education, Research, and Recovery Fund acts as a critical safety net. The fund is financed by fees collected from licensees at the time of initial licensure and during subsequent renewals. To be eligible for compensation from the fund, a consumer must have obtained a valid court judgment against a licensee for damages suffered due to activities requiring a license. However, the law imposes specific limitations on these payouts, including a cap on the amount payable per transaction and a cumulative maximum per individual licensee. Once the fund pays out a claim on behalf of a licensee, that individual's license is effectively suspended until they reimburse the fund in full, plus interest. This repayment requirement underscores the seriousness with which the Commission views the protection of public assets. It exists to provide a final recourse for damages that cannot be recovered through typical legal channels, ensuring that the integrity of the industry isn't undermined by the actions of a few individuals. See you in the next lecture. Welcome to the chapter on licensing requirements and status changes, where we will build a solid foundation for understanding the regulatory environment you are about to enter as a professional. This material is designed to ensure you possess the technical proficiency required to navigate the complexities of Georgia real estate law with absolute confidence. Obtaining a Georgia real estate license is a structured process that mandates specific qualifications to protect the public interest. To qualify as a salesperson, you must be at least 18 years of age and hold a high school diploma or its equivalent. Beyond these basic requirements, applicants must successfully complete a 75-hour salesperson pre-license course approved by the Georgia Real Estate Commission. However, completion of the coursework is merely the preliminary step, as every applicant is also required to submit to a comprehensive criminal background check. This background clearance is vital because certain past offenses can result in the automatic denial of your application, regardless of your educational achievements. Understanding these barriers early helps you prepare appropriate documentation for the Commission if your history contains any flags. The Commission evaluates each case individually, weighing the nature of the offense against the protection of the public. If you intend to pursue a broker or associate broker license, the requirements become substantially more rigorous and demand a higher level of professional experience. Brokers must typically demonstrate active experience in the field, often necessitating years of practice before the Commission considers their application for a higher tier license. Once you are licensed, your education journey is far from over, as the Commission enforces strict continuing education mandates to maintain professional standards. New licensees are specifically required to complete a 25-hour post-license course within their first year of licensure to ensure they transition effectively into professional practice. Failure to complete this specific post-license requirement within the allotted time frame will result in the automatic lapse of your license, which is a mistake that can be costly to rectify. Beyond this initial hurdle, every licensee must satisfy ongoing continuing education requirements during each 4-year renewal cycle. You must typically complete 36 hours of approved continuing education, which ensures that all practitioners remain current with evolving laws and ethical standards. These cycles are tied directly to your birth date, making it essential to track your individual deadlines meticulously. When a renewal is missed, the Commission imposes significant late penalties, and engaging in any professional activity while your license is expired constitutes a violation of law. Your eligibility to receive commissions is inextricably linked to the active status of your license at the time a transaction is closed. Managing your license status requires a nuanced understanding of how to transition between active, inactive, and affiliated states. An inactive license status is an option for brokers or salespeople who wish to hold their license without being actively associated with a broker. While your license is inactive, you do not need to maintain errors and omissions insurance, but you are strictly prohibited from performing any acts that require a license. If you decide to return to active practice, you must find a sponsoring broker and submit the appropriate application to the Commission to change your status. Similarly, if you choose to move your license between brokerages, you must follow the Commission's formal notification procedures. This process involves the current broker releasing your license and the new broker accepting you, which must be documented accurately through the regulatory portal. Deadlines for these communications are strict, and delays can lead to unassigned time during which you are technically unlicensed. Ensuring your broker is aware of your intent to move or change status is a professional courtesy that also protects your legal standing as a practitioner. The globalization of real estate markets necessitates that we also examine how Georgia handles non-resident licensing and reciprocity agreements. If you are licensed in another state, you may be eligible for a non-resident license through reciprocity, provided that Georgia has an active agreement with your home jurisdiction. These agreements are not universal, so you must verify the specific standing of your home state with the Commission before assuming you can practice in Georgia. Even with reciprocity, you must still comply with all Georgia laws and maintain your continuing education requirements, as if you were a resident. Additionally, we must touch upon the complexities of dual agency, which requires a separate set of disclosures and explicit written consent from all parties involved. Participating in dual agency without adhering to the precise statutory requirements is a frequent source of disciplinary action. You must understand these rules clearly, as they represent the thin line between a legal professional agreement and a violation of fiduciary duty. Mastering these concepts is essential for maintaining your practice in a legally compliant and ethical manner throughout your career. I will see you in the next lecture. Welcome back. In this lesson, we will focus on the fundamental requirements for maintaining trust accounts under Georgia law to ensure your brokerage remains in total compliance. When you act as a real estate broker in Georgia, you are essentially serving as a fiduciary for your client's money. This is a profound responsibility that the Georgia Real Estate Commission takes very seriously. A trust account, often referred to as an escrow account, exists solely to hold funds belonging to others. These accounts must be separate from your personal or business operating accounts to prevent any accidental usage of client funds for company expenses. If you fail to maintain this separation, you are stepping into a territory that can quickly lead to the revocation of your license. The law specifically mandates that these accounts be maintained at a federally insured banking institution in Georgia. You must notify the commission of the account name and number within 1 month of opening the account, unless you are a broker who does not handle any client money at all. One of the most critical aspects of trust account management involves the strict prohibition of commingling and conversion. Commingling occurs when a broker mixes personal or business operating funds with the trust funds belonging to clients. Even if you intend to move those funds quickly, the mere act of mixing them constitutes a violation of Georgia license law. Conversion is an even more serious offense, where a broker actually uses the client funds for their own benefit or for the benefit of someone other than the person to whom the money belongs. To avoid these issues, your accounting systems and record-keeping practices must be robust, reliable, and transparent. The Commission mandates that all relevant financial records must be kept for a period of at least 3 years, and they must be readily available for inspection during a GREC audit. When it comes to earnest money, the timeline is not merely a suggestion, but a legal requirement for prompt deposit. As a licensee, you are responsible for ensuring that earnest money is deposited into the designated trust account within the timeframe specified in the purchase agreement. If the agreement is silent, current industry standards generally require deposit by the end of the next business day following the acceptance of the contract. You must always maintain a formal ledger that tracks each separate transaction so that you can identify exactly how much of the balance in the trust account belongs to each client at any given moment. This level of granular detail allows you to prove to an auditor that you are holding the correct amount of money for every active transaction. If a dispute arises over the ownership of the earnest money, you must follow the precise resolution procedures dictated by the contract and the law, which usually involve keeping the funds in escrow until both parties provide written instructions or a court order is issued. A broker bears the ultimate legal responsibility for the management of the trust account, even if they delegate the daily record-keeping duties to a bookkeeper or an administrative assistant. You cannot use delegation as a defense if your affiliate licensees engage in improper handling of money. Part of your supervisory duty involves periodic reviews of the account and the underlying transactions to identify any anomalies. Interest-bearing accounts are permissible in Georgia, but you must ensure that all parties clearly understand and agree in writing on who will receive the interest earned. Without such written authorization, interest accrued on the account must not be diverted to the broker. Any departure from these statutory requirements, particularly those relating to the Georgia General Assembly's regulations on fiduciary duties, can lead to substantial fines, administrative penalties, and the irreversible loss of your professional license. See you in the next lecture. Welcome to this session on the regulatory landscape governing how you present your services to the public. We are going to explore advertising standards and the boundaries of fair trade practices in Georgia. In the state of Georgia, professional advertising is not merely a matter of creative marketing. It is a rigid legal compliance activity. The Georgia Real Estate Commission dictates that any advertisement released by a licensee must be under the direct supervision and approval of the broker. A critical mandate is the inclusion of the brokerage trade name in any advertisement, which must be clearly and conspicuously displayed. Furthermore, if you are advertising on platforms where physical space is limited, the brokerage name must be identified in a way that represents a clear and meaningful connection to your services. You cannot simply use your own name without linking it to the firm, and the font size for the brokerage firm name must be equal to or larger than the font size used for your name as an individual licensee. This ensures that the public is never confused about which firm is responsible for the transaction or the professional representation being advertised. We must also address the concept of blind ads, which are strictly prohibited under state regulations. A blind ad occurs when a licensee attempts to advertise a property for sale or lease without disclosing the brokerage firm's name. This practice is dangerous because it hides the professional involvement of the firm, preventing the public from identifying the licensed entity responsible for the listing. Additionally, you must be hyper-aware of the Georgia Fair Business Practices Act and the Uniform Deceptive Trade Practices Act. These laws prohibit any communication that misleads the public, creates false impressions, or implies guarantees that cannot be factually supported. As a licensee, you are effectively a representative of your firm, and any communication that deviates from the truth can lead to severe disciplinary actions, including the potential loss of your license. The issue of misrepresentation carries significant weight in Georgia law, particularly regarding the inducement of a breach of contract or the promise of future profits. You cannot promise a client that a property will appreciate at a specific rate or guarantee a return on investment, as these are inherently speculative and outside of your control. Any statement you make regarding potential equity gains must be rooted in documented historical data rather than subjective opinion. Furthermore, if you're a licensee selling or buying property for your own personal gain, you're legally required to disclose your license status in writing. This must be done prominently, ensuring that all parties involved in the transaction are fully aware that they are dealing with a licensed professional. Failing to disclose this interest is considered a failure to practice with the transparency the law necessitates. Steering and redlining represent egregious violations of federal and state fair housing laws that often intersect with advertising practices. Steering involves the illegal act of guiding potential buyers toward or away from specific neighborhoods based on protected classes rather than their personal financial qualifications or specified needs. Redlining, meanwhile, involves the discriminatory practice of denying loans or services in specific areas, which is often tied to the racial or ethnic composition of those neighborhoods. While these relate to broader fair housing mandates, they're directly tied to your advertising and marketing decisions when you profile potential clients. You must strictly avoid any language in your marketing collateral that could be interpreted as discriminatory or limiting. Your duty is to offer services in a neutral, professional manner that adheres to the spirit of fair competition and equal access. The legal consequences for engaging in these prohibited practices are designed to protect the integrity of the real estate market in Georgia. If a licensee is found to have engaged in misleading disclosures or deceptive marketing, the Real Estate Commission has the authority to impose heavy fines, suspend licenses, or even issue permanent revocations. These measures exist because the license itself is a grant of trust from the public. When you market a property, you're not just selling a physical asset. You are demonstrating your adherence to the statutes that keep the market functional and fair for all participants. Understanding these rules is your primary defense against unintentional violations that could end your career before it fully begins. We will move into the next area of our curriculum now. Welcome to the chapter focused on the Georgia Real Estate Education, Research, and Recovery Fund. In this series, we will examine the specific mechanics of this consumer protection mechanism and its impact on your professional obligations. The Georgia Real Estate Education, Research, and Recovery Fund functions as a critical safety net mandated by state law to protect the public from financial loss caused by a licensee's violation of real estate laws or regulations. Unlike common insurance policies, this is a state-governed fund that draws its primary capital from real estate licensees themselves. When an individual applies for an initial license, a portion of the fee is designated for this fund. Furthermore, if the fund balance drops below a specific statutory threshold, the Georgia Real Estate Commission has the authority to assess additional fees against active licensees to replenish the reserves. This structure ensures that the industry effectively self-funds a mechanism to address damages when a broker or salesperson fails to adhere to professional standards. You should view this not merely as an administrative tax, but as a fundamental pillar of public trust that sustains the legitimacy of the real estate profession in Georgia. The fund is specifically designed to provide a remedy when a court judgment has been obtained against a licensee, but the claimant remains unable to collect the awarded damages through standard legal recovery methods. To access the fund, an aggrieved citizen must navigate a precise legal process that requires exhaustion of all other available remedies. A claimant must first secure a final judgment from a court of competent jurisdiction against the real estate licensee for violations involving embezzlement, conversion of trust funds, or other prohibited acts under the license law. Once the judgment is final, the claimant must prove that they have pursued all available legal processes and still remain unable to recover the full amount of the judgment. Only then can the claimant petition the Commission for payment, providing evidence of the underlying judgment and their inability to collect. We must note that the fund is not intended to cover every minor grievance. It operates within strict limits to ensure sustainability. The maximum payout per transaction is generally capped at $25,000, regardless of the number of individuals involved in the incident. Furthermore, the total liability for the acts of a single licensee is limited to $75,000 total, which acts as a ceiling for claims against the fund originating from that specific agent. If the Commission authorizes a payment from the fund as a result of a licensee's violation, the consequences for that licensee are immediate, severe, and automatic. By operation of law, the licensee's license is suspended the very moment a payment is made from the fund on their behalf. This suspension is not discretionary. It is a rigid regulatory response intended to remove potentially bad actors from the market until the financial integrity of the fund is restored. The reinstatement of the license is not simply a matter of time passing, but requires full restitution to the fund. The licensee must repay the original amount paid out to the claimant, plus mandatory interest at an annual rate designated by the statute. Until this debt is cleared in full, the individual cannot resume practicing real estate in Georgia. This creates a powerful deterrent against fraud and negligence, as it ensures that the burden of bad conduct ultimately rests back upon the individual licensee rather than being permanently socialized across the industry. Throughout your practice, you should categorize this fund as a consumer protection mechanism designed to bolster public confidence in the real estate sector. By requiring financial skin in the game through fees, the Commission ensures that the industry as a whole is incentivized to maintain high ethical standards to avoid depletion of the fund. Understanding these rules is essential for your exam because the state wants to see that you comprehend both your personal liability and the regulatory environment governing your profession. While we rarely encounter situations where the fund is triggered, the existence of these rules dictates how brokers handle trust accounts and professional conduct daily. When questions arise regarding professional boundaries, remember that the recovery fund is the final line of defense against insolvency caused by license law violations. Keeping these financial consequences in mind will help you internalize the importance of strict compliance with trust account management and ethical brokerage practices. It is a system built on accountability, and your professional future in this state depends on your ability to operate comfortably within these defined constraints. See you in the next lecture. Welcome back. In this lesson, we will examine the specific mechanics of brokerage agency status and the mandatory supervisory framework required by Georgia license law. To understand the operational structure of a real estate firm, we must first address the professional classification of the agents affiliated with a broker. In Georgia, licensees generally operate as independent contractors rather than traditional employees, a distinction that carries significant weight regarding tax obligations and administrative control. While a broker maintains strict supervisory authority over the licensure and professional conduct of a salesperson, the broker does not exercise the same level of granular control over the method and means of performance as an employer would with staff. This status is codified in the written employment agreement, which must clearly delineate the responsibilities of both parties to avoid misclassification issues. Even though an agent functions as an independent business entity for tax purposes, the broker remains legally responsible for the actions that person takes while engaging in real estate activities. This creates a unique professional bond where autonomy and strict oversight coexist, ensuring that the firm maintains a defensible position under Georgia Code Title 43, Chapter 40. Failure to properly document this relationship can invite scrutiny from both the Department of Labor and the Georgia Real Estate Commission. Therefore, maintaining precise records of these agreements serves as the foundation for a compliant brokerage operation. The supervisory burden placed upon a broker is comprehensive and extends to every licensed affiliate acting under the firm's umbrella. Under Georgia law, the broker is not merely a figurehead, but an active manager who is personally accountable for the review of all contracts and transactional documents generated by their agents. This requirement exists to ensure that every agreement meets legal standards before it becomes a binding obligation between a buyer and a seller. Beyond document review, the broker must actively advance the education and professional competency of their subordinates, keeping them informed of changes in license law or standard practice. If a broker fails to implement a system of supervision, they become vulnerable to administrative sanctions, regardless of whether they had direct personal knowledge of a specific agent's error. This is where the concept of vicarious liability becomes highly relevant, as a broker can be held liable for the professional errors or omissions of their affiliated licensees. To mitigate this risk, firms rely heavily on errors and omissions insurance, which provides a safety net for professional negligence. Even with insurance, the prevention of misconduct remains the broker's primary legal duty, necessitating proactive oversight rather than reactive damage control. The structural integrity of a brokerage is defined by how it chooses to handle the agency relationships its agents enter into with the public. Georgia law provides several frameworks for these relationships, each with distinct mandates concerning confidentiality, loyalty, and the scope of services provided. Designated agency, for instance, occurs when a broker assigns one agent to represent the buyer and another to represent the seller in the same transaction, effectively isolating the client information within the firm. In contrast, dual agency represents a more complex path, requiring explicit written consent from both parties because the broker assumes a limited role that precludes the advocacy of specific interests. Many firms have shifted toward acting as transaction brokers, where the agent provides only ministerial acts and does not represent either party as a client. This approach is intended to minimize the potential for conflicts of interest while still providing the necessary guidance for a real estate closing. Because these roles are statutory in nature, a broker must be diligent in ensuring that the brokerage engagement agreements correctly reflect the relationship being established. Understanding these distinctions is not just about fulfilling administrative paperwork. It is about clearly establishing the legal duties owed to the parties involved. When the professional relationship between a broker and a licensee ends, the procedure for disassociating the license must be handled with precise attention to regulatory timelines. The broker is responsible for ensuring that the license is returned to the Georgia Real Estate Commission in a timely manner so that the status of the former affiliate is updated in the state database. This formal act of disassociation effectively severs the broker's liability for the agent's future real estate activities, marking the official end of the supervisory bond. During this process, the broker must also ensure that the licensee's pending transactions are appropriately handed off or resolved so that no client is left without representation or information. Any remaining disputes regarding commissions or outstanding contract duties must be settled in accordance with the policies established in the original written agreement. Following these exit protocols strictly is as important as the initial hiring phase, as the Commission keeps a close eye on the ledger of active and inactive status applications. Documentation of these changes provides a clear audit trail, proving that the broker fulfilled their obligations until the final moment of professional separation. See you in the next lecture. Welcome to this exploration of the Brokerage Relationships in Real Estate Transactions Act. We will unpack how this legislation defines the professional landscape for licensees in Georgia. In the state of Georgia, the Brokerage Relationships in Real Estate Transactions Act, commonly abbreviated as BRRETA, serves as the definitive statutory framework governing the relationships between brokers and the public. Before BRRETA, real estate agency was largely governed by common law principles, which were often ambiguous and subject to varying interpretations by courts. By establishing this act, the Georgia legislature provided a clear, codified set of rules that preempts common law agency doctrines. This legislative shift was intended to eliminate confusion and establish a predictable standard of conduct that all licensees must adhere to when interacting with both clients and customers. Understanding this transition is essential because BRRETA defines exactly what a broker is not required to do, in addition to what they are obligated to provide. When you encounter scenarios on your exam involving agency duties, always look for the BRRETA definitions first, as they supersede traditional common law interpretations. This statutory framework essentially maps out the boundary lines for professional liability and authority, creating a safer harbor for brokers who follow its mandates. To navigate BRRETA effectively, we must master the distinction between a client and a customer. A client is a person who has entered into a written brokerage engagement with a broker, thereby creating a formal, fiduciary-like relationship. Conversely, a customer is a person with whom the broker is having discussions, but who has not signed a brokerage engagement. This distinction is the bedrock of your professional behavior, as the duties owed to a client are significantly more robust than those owed to a customer. A brokerage engagement is the written contract that establishes the relationship, and it must be clearly defined to ensure that the parties understand their respective rights. Without this written agreement, the relationship defaults to that of a customer, which inherently limits the broker's ability to provide advice or advocacy. Consequently, failing to execute these documents correctly can lead to unintended liability and violations of the commission rules that you are expected to enforce as licensees. Another vital component of the Act is the definition of material facts, which are specific facts relating to a property or a transaction that a party could not reasonably discover through a formal inspection or inquiry. Under BRRETA, brokers have a duty to disclose these material facts, even if they are not explicitly asked about them by a party. This duty is non-negotiable and exists regardless of whether the party is a client or a customer, though the depth of the inquiry expected of the broker may differ. The Act specifically limits a broker's liability for misrepresentations made by other parties, such as a seller or a home inspector, provided the broker did not have actual knowledge of the falsehood. This provision is designed to ensure that you are not held accountable for the deceit or negligence of others, provided you remain diligent and honest in your own representations. You're not expected to be a surrogate for a home inspector, yet you must still be transparent about what you know. The duration of these relationships and the rules regarding their automatic termination are also clearly outlined within the statute. Unless a definite termination date is specified in the brokerage engagement, the agreement will automatically terminate exactly 1 year after it is initiated. This rule prevents open-ended agreements that could inadvertently trap a party in a relationship for longer than they intended. Furthermore, the Act specifies that the duties of the broker to the client do not end immediately upon the closing of a transaction, but rather conclude upon the completion or expiration of the engagement. Confidentiality obligations, however, often persist even after the agency relationship has ceased, protecting the sensitivity of the data shared during the active period. Being mindful of these timelines is a matter of administrative prudence, as it protects both your professional standing and the interests of the individuals you represent in the transaction. Maintaining a firm grasp on these definitions ensures that you are providing competent, legally sound service to the public. As you prepare for the board exam, view BRRETA not as a burden of regulations, but as a roadmap for ethical and professional conduct in every interaction. I will see you in our next session. Welcome back. In this lecture, we will perform a detailed comparison of the statutory duties owed to clients versus the limited assistance provided to customers under the Brokerage Relationships in Real Estate Transactions Act. To understand the legal landscape in Georgia, we must first distinguish between a client and a customer, as this relationship fundamentally dictates the scope of the broker's responsibilities. A client is a person who has entered into a written brokerage engagement with a broker, creating a formal fiduciary or contract-based relationship. In contrast, a customer is a person who has not entered into such an agreement, but is being assisted by a broker in a real estate transaction. This distinction is not merely a formality, but a statutory trigger that activates different levels of care. When you serve a client, you are bound by broad duties of loyalty and advocacy that do not exist for the casual customer. Treating these two categories identically is a common error that leads to regulatory scrutiny and potential liability. By clearly defining the status of the parties at the first substantive contact, you ensure that your actions align with the law. This classification process serves as your primary defense against claims of undisclosed dual agency, which can jeopardize your license. When representing a client, a broker must prioritize the client's interests above all others, except for the duty of honesty and the obligation to disclose material facts to all parties. This high standard of care includes the duty of loyalty, which means you must act solely in your client's best interest, even if it runs counter to your own personal gain. Furthermore, you owe your client the duty of confidentiality, requiring you to protect their secrets, motives, and bargaining positions throughout the process and even after the engagement ends. Accounting is another core pillar, necessitating meticulous tracking of all funds and property entrusted to your care during the transaction. You are also required to exercise reasonable skill and care, which implies a duty to stay informed on market conditions and regulatory changes. If you fail to advocate for your client's specific interests, you are essentially failing to perform the core service for which you were contracted. These duties remain binding until the transaction closes or the brokerage engagement is formally terminated. Customers, on the other hand, are owed a much more limited set of duties that revolve primarily around honesty and the disclosure of specific facts. You do not owe a customer the duty of loyalty, meaning you are not required to advocate for their financial interests or keep their motivations confidential. Instead, your responsibility is to perform ministerial acts, which are administrative tasks that do not involve the exercise of personal judgment or discretion. Examples of ministerial acts include showing properties, providing factual information about the local market, or pointing out existing listings that match a customer's criteria. While you must remain honest, you are not obligated to protect a customer in the same way you would a client. This distinction is vital because overstepping these limits can lead a customer to mistakenly believe they are entitled to your undivided professional advocacy. You must communicate the nature of the relationship clearly from the beginning to set appropriate expectations and maintain your compliance posture. Regarding adverse material physical defects, the duty to disclose extends beyond your own clients to include customers and even third parties. If you have actual knowledge of a material physical defect on a property, you're legally obligated to disclose it, even if your client asks you to keep that information private. This requirement is intended to prevent the perpetuation of fraud and to ensure that all participants in a transaction have access to accurate information. A material fact is anything that could significantly impact a buyer's decision or a property's value, such as structural issues, environmental hazards, or known legal encumbrances. You are not required to perform an exhaustive investigation to discover these issues, but you must report what you already know. Ignoring this requirement often leads to litigation and claims of misrepresentation by the broker. Transparency in these disclosures maintains the integrity of the transaction and protects your professional reputation in the Georgia real estate market. The concept of ministerial acts is designed to allow brokers to assist customers without inadvertently creating an agency relationship. An act is considered ministerial when it is essentially mechanical or routine, such as preparing an offer or delivering documents, rather than providing advice or negotiation strategy. If you start providing opinions on the fairness of a contract price or recommending specific bargaining tactics to a customer, you have moved into the realm of discretionary acts. Discretionary acts require the use of professional judgment for the benefit of another, which effectively signals that you are acting as their agent. By avoiding these actions when working with customers, you maintain the clear boundary between a client-agent relationship and a consumer service relationship. Always remember that your status as a licensee requires you to manage these boundaries carefully to avoid the pitfalls of unauthorized agency. Understanding where your duty to advocate ends and your duty of general service begins is essential for every successful practitioner. See you in the next lecture. Welcome to our deep dive into the disclosure obligations under Georgia law. We will examine the specific duties a licensee holds regarding property condition and material facts. In Georgia, the concept of a material fact is central to the ethical and legal obligations of a real estate licensee. When we talk about material facts, we are referring to information that could significantly impact the decision of a reasonable person to enter into a contract or affect their willingness to pay a certain price. This includes physical defects that are not readily apparent to the naked eye, often referred to as latent defects. Structural instability is a prime example of a latent defect that must be disclosed because it directly affects the safety and habitability of the property. Similarly, active infestations, such as termites or other wood-destroying organisms, are considered material because they pose an ongoing threat to the integrity of the building. You must understand that the duty to disclose these items does not rely on whether you have a personal opinion on their severity. If the fact is material and known to the licensee, the requirement to disclose it to all parties in the transaction is absolute. This is not merely a courtesy, but a foundational requirement to protect the integrity of the real estate market. The management of the seller's property disclosure statement carries its own set of critical responsibilities for a broker. While the seller is responsible for the accuracy of the information provided in this document, the licensee occupies a position of oversight. You have a legal obligation to ensure that the client understands their duty to be truthful and to disclose known defects to the best of their knowledge. If a licensee receives information that contradicts the claims made in a disclosure statement, they cannot simply remain silent. Ignorance is not a valid defense when a professional has reason to believe that a statement is fraudulent or inaccurate. Furthermore, when a buyer asks a direct question, the duty of honesty takes precedence over any desire to avoid an uncomfortable conversation. Honesty requires that you answer truthfully, without resorting to half-truths or calculated omissions that might mislead the buyer. Your role is to facilitate the exchange of information, not to filter it to favor your client's interests at the expense of legal transparency. When we shift our focus to stigmatized properties, Georgia law becomes quite specific, requiring a nuanced understanding of what must and what must not be disclosed. A property can be deemed stigmatized due to events such as a homicide, a suicide, or the presence of an occupant with an infectious disease like HIV or AIDS. Under Georgia statutes, a licensee is generally not required to volunteer information regarding these specific psychological or medical stigmas. However, there is a clear distinction between volunteering information and answering a direct inquiry. If a prospective buyer or their agent asks a question regarding whether a property was the site of a homicide or an infectious disease event, you must answer truthfully if you have actual knowledge of the facts. Providing false information in response to such an inquiry can lead to significant liability and potential disciplinary action. This framework balances the seller's right to privacy regarding events that do not physically impair the property with the buyer's right to receive accurate information when they specifically request it. Brokers also carry the burden of conducting a reasonable inspection to uncover visible adverse conditions during the listing process. This does not mean that a broker must be a structural engineer or a home inspector capable of identifying every nuance of plumbing or electrical failure. Instead, it means that you must observe and report what is visibly obvious during a walkthrough of the property. If you see signs of water intrusion, sagging floors, or mold-like substances, that information must be integrated into your understanding of the property's condition. While you're not expected to move furniture or peel back drywall, you are expected to look with a professional eye. This duty is intrinsically tied to the overall requirement to promote fairness in the transaction for all involved parties. By maintaining this standard of minimal inspection and vigilant disclosure, you help ensure that the transaction proceeds on a path of transparency rather than one of hidden variables. See you in the next lecture. Welcome back. In this lesson, we will examine the statutory requirements for brokerage engagements under Georgia law to ensure you have the precision necessary for your state board exam. In Georgia, the Brokerage Relationships in Real Estate Transactions Act, commonly known as BRRETA, mandates that all brokerage engagements must be in writing to be legally enforceable. This requirement is not merely a formality, but a core consumer protection mechanism designed to ensure that both the broker and the client have a mutual understanding of their duties and compensation. When we talk about a listing agreement or a buyer brokerage engagement, we're talking about an employment contract between a broker and a principal. Because this relationship establishes a fiduciary or a transaction broker role, the law demands specificity to avoid ambiguity. You must remember that a valid engagement requires a definite expiration date, which prevents these agreements from lingering indefinitely. If an agreement lacks a termination date, a court will likely deem it unenforceable, which creates significant liability risks for the practicing licensee. Beyond the expiration date, these written agreements must clearly articulate the terms of broker compensation. Whether the fee structure is a percentage of the sales price, a flat fee, or some other predefined arrangement, the document must capture it in writing. Often, students get tripped up on the requirement for signatures. It is not enough for the broker to simply draft the document. Every party to the contract must sign the agreement to provide the necessary legal consent for the broker to act on their behalf. Furthermore, if the engagement involves a specific piece of real property, you must include a proper legal description of the property. Simply referencing an address is often insufficient for formal documentation because addresses can change or prove ambiguous in a legal dispute. Including a formal legal description, such as a meets and bounds description or a reference to a recorded plat, solidifies the scope of the engagement. Georgia law is extremely strict regarding the duration of these contracts, specifically regarding the prohibition of automatic renewals. If a contract contains a provision that magically extends the agreement without active, affirmative consent from the client, that provision is void. You should view these agreements as finite instruments that require a professional touch to renew or extend. This restriction serves to prevent brokers from locking clients into long-term arrangements they may have forgotten about or no longer desire. Along with the logistics of timing and compensation, the written engagement must also encompass the mandatory disclosures regarding agency relationships. BRRETA requires that the nature of the broker-client relationship be defined, meaning the document must explicitly state whether the broker is acting as a seller's agent, a buyer's agent, a dual agent, or a transaction broker. When we shift our focus to the termination of these agreements, there are specific protocols that you must be aware of for the exam. While the primary obligation to perform terminates on the expiration date, certain duties and obligations, such as confidentiality, survive the expiration. Understanding this survival clause is critical because a broker cannot disclose a former client's confidential information even after the listing or buyer engagement has officially closed or expired. This legal principle ensures that the trust established during the agency relationship remains intact long after the professional business cycle has concluded. Failing to maintain this confidentiality after the contract expires is a direct violation of the standards set by BRRETA and could lead to disciplinary action by the Commission. Keeping these boundaries clear and documented allows the licensee to operate with the level of professional integrity that the Georgia real estate laws intend to cultivate. I will see you in the next lecture. Welcome to our next session regarding the intricacies of agency relationships under Georgia law. Today, we will examine the mechanisms of dual and designated agency as governed by the Brokerage Relationships in Real Estate Transactions Act. In the context of real estate transactions, agency defines the fiduciary baseline within which a licensee operates. Dual agency occurs when a single real estate licensee represents both the buyer and the seller in the same transaction. Because a fiduciary duty inherently necessitates placing one client's interest above all others, the existence of two clients creates a conflict of interest that must be navigated with extreme precision. Under Georgia law, this arrangement is only permissible if the broker obtains informed, written consent from all parties before any progress is made on the transaction. This disclosure is not merely a formality, but a mandatory prerequisite that alerts the parties to the limitations placed upon the agent. Once dual agency is established, the agent is effectively neutered regarding their ability to negotiate aggressively for either side. You must be prepared to explain to your clients that the agent can no longer advocate solely for one party's financial gain or disclose personal motivations for the sale or purchase. To mitigate the inherent conflicts involved in dual agency, the concept of designated agency serves as an alternative structure within a brokerage firm. Designated agency allows a broker to assign one specific licensee to the buyer and a different licensee to the seller, even though both agents operate under the same managing broker. This structural separation effectively isolates the representation, allowing the designated agents to continue providing as much advocacy as possible given the shared brokerage affiliation. However, the broker remains in a dual agency role because they hold the ultimate responsibility for all transactions occurring under their license. To prevent illegal, undisclosed agency, firms must implement functional confidentiality walls to ensure that protected information, such as the buyer's max purchase price or the seller's minimum acceptable offer, does not bleed between the designated representatives. If information flows freely between these agents, the legal distinction of designated agency collapses, exposing the broker to significant liability for failing to maintain client interests. The legislative framework provided by BRRETA requires that these relationships be documented thoroughly to manage legal exposure. When acting as a dual agent, the licensee is legally required to disclose the sources of compensation and must remain impartial. The law expects the licensee to perform ministerial acts for both parties while strictly avoiding actions that could be construed as preferential treatment. This means you cannot counsel a seller on how to reject an offer based on a buyer's previous negotiations if you also represent that buyer. Failure to properly document these conflicts or to obtain the necessary signatures on a dual agency consent form is a violation of the Georgia Real Estate Commission rules. The risk here is not just an administrative fine. It is the potential for losing the commission entirely if a court determines that the undisclosed or improperly managed dual agency breached the fiduciary standard. Understanding these nuances is essential for your success on the state board exam and for your future practice in the field. As you study these provisions, remember that the burden rests entirely upon the licensee to ensure that every participant in the transaction is fully aware of their representation status. The impartiality required in dual or designated agency does not mean you stop providing information. Rather, it means you provide the same level of objective, factual material to both sides without weaving in personal strategy or opinion. Think of yourself as an information conduit rather than a negotiator when these configurations are at play. By strictly adhering to the written consent requirements and maintaining the confidentiality of your respective clients, you protect the broker and yourself from claims of statutory violations. These procedures exist to uphold the integrity of a market while allowing brokers to facilitate transactions that might otherwise be impossible. Review your statutory definitions closely to ensure you can distinguish between the duties owed in a standard brokerage engagement and those mandated by these specialized agency forms. See you in the next lecture. Welcome to this chapter, where we will examine the statutory role of the transaction broker and the scope of ministerial acts under Georgia law. Understanding this specific brokerage relationship is essential for passing the state exam and maintaining compliance in your future practice. In the state of Georgia, the Brokerage Relationships in Real Estate Transactions Act, commonly known as BRRETA, provide a clear framework for how licensees interact with the public. A transaction broker is a licensee who chooses not to represent either the buyer or the seller as a client, but instead acts as a facilitator for the transaction. This relationship is distinctly non-agency, meaning the broker does not owe fiduciary duties such as loyalty, obedience, or confidentiality to either party. Instead, the transaction broker remains a neutral party, performing services that are categorized as ministerial acts without creating an implied agency relationship. By adopting this structure, Georgia provides licensees with the flexibility to assist parties who do not wish to enter into a formal representation agreement, while simultaneously protecting consumers from the accidental creation of agency. It is a vital distinction because, unlike a buyer or seller agent, a transaction broker does not advocate for the best interest of one party over the other, but rather focuses on the successful completion of the transaction itself. The primary requirement is that the licensee must act with honesty and must disclose all material adverse facts about the property that the broker knows or should know, even if those facts are not immediately obvious. To understand the practical application of this role, we must precisely define what constitutes a ministerial act. Under BRRETA, these are tasks that do not involve the exercise of personal judgment or the use of discretion regarding the negotiation of terms. For example, a licensee acting as a transaction broker can provide factual information about a property, such as its square footage, the age of the systems, or the general data regarding schools and neighborhood amenities. They can assist in preparing documents by filling in the blanks on pre-approved, standardized forms, provided they do not alter the intent of the parties or insert legal language for which they are not qualified. Delivering documents, such as offers, counteroffers, or notices, is a classic ministerial act because it involves the mechanical transfer of information rather than the provision of advice. This scope also includes identifying common sources of professional services, like inspectors or lenders, without endorsing any specific one over another. By keeping these activities strictly informational and administrative, the broker successfully avoids stepping into the role of a fiduciary advocate. These acts are designed to be helpful and objective, ensuring that the contractual process moves forward without the complex, often conflicting duties of agency representation being introduced. The shift to a transaction brokerage relationship usually happens either by a written agreement between the broker and the parties, or by the broker defaulting to this role in the absence of an agency engagement. There is inherent benefit here regarding limited liability, as the broker is not held to the high standard of fiduciary care that typically attaches to a client-agent relationship. However, the requirement to disclose material adverse facts remains an absolute, non-waivable responsibility for any licensee, regardless of their status. If you are aware of a major defect in the property, such as a structural issue or a significant environmental hazard, you must disclose it to all parties to the transaction. Compensation in this model is still typically paid by the principal parties involved, but it is defined by the service agreement rather than a commission predicated on fiduciary loyalty. You will find that understanding this distinction is a frequent topic on the state examination, as it tests your ability to identify when a licensee might be overstepping into unauthorized agency or failing to perform necessary ministerial duties. When you act as a transaction broker, you are essentially functioning as a diligent, honest, and well-organized facilitator, which provides clarity for all parties involved in the real estate transaction. See you in our next session. Welcome to our exploration of Georgia Association of Realtors forms and the fundamental principles of contract law governing real estate transactions. In this section, we will establish the necessary foundation to navigate the most critical documentation used in professional practice across the state. If you're serious about passing the Georgia State Board exam, mastering GR forms is not just a suggestion, but a prerequisite for success. This specific module distills complex legal jargon into actionable knowledge that you will apply daily in the field while simultaneously preparing for high-stakes test questions. We will dissect the anatomy of standard agreements and clarify the legal boundaries that define your role as a licensee versus the practice of law. By the time we conclude this series, you will possess a robust understanding of how to construct enforceable contracts that protect the interests of all parties involved. This course offers you the most precise path to certification by focusing on the rules that examiners prioritize in every iteration of the test. At the core of any real estate transaction in Georgia is the requirement for a valid, enforceable contract, which is governed by basic principles of contract law. For a contract to be legally binding, you must demonstrate the presence of competent parties, mutual assent through a valid offer and acceptance, and the exchange of consideration. Competency implies that the individuals involved have the legal capacity to enter into an agreement, meaning they are of legal age and sound mind. The offer and acceptance process involves a meeting of the minds, where terms are clearly understood and agreed upon without duress or undue influence. Consideration, which is the value exchange between parties, must be present, though it does not necessarily need to be a large sum of money. Finally, the contract must have a legality of object, ensuring that the purpose of the agreement does not violate any state or federal laws. Georgia law places significant weight on the statute of frauds, which mandates that any contract for the sale of real property must be in writing to be legally enforceable. This requirement serves to prevent litigation based on oral promises, which are notoriously difficult to verify in a court of law. When discussing property, the description must be accurate and legally sufficient to identify the specific tract of land, which usually requires a reference to a recorded deed or a plat map. Without an adequate legal description, the contract risks being declared void due to ambiguity. You must always ensure that the physical definition of the property is precise to avoid conflicts during the title search or closing processes. Remember that the statute of frauds is an absolute barrier for verbal agreements in real estate, so never rely on spoken arrangements when binding your clients to a transaction. Effectively filling out the purchase and sale agreement requires meticulous attention to every field, as omissions often lead to costly professional liability for agents. You're tasked with facilitating the transfer of intent onto paper, meaning every choice regarding contingencies, timelines, and financial terms must be legible and unambiguous. Special stipulations and addenda are the tools you use to customize standard forms to the unique needs of a transaction, but they're also the most common source of legal trouble. A poorly drafted stipulation can inadvertently void a contract or create obligations that exceed the scope of your initial agreement. Always utilize approved GR forms wherever possible, as these have been vetted for compliance with current Georgia statutes. If a party requests an arrangement that falls outside the scope of pre-drafted language, you must recognize the immense risk inherent in drafting your own legal clauses. This brings us to the critical distinction between a real estate licensee and an attorney, specifically regarding the unauthorized practice of law. Because you are compensated for brokerage services, You are permitted to fill in the blanks of standard forms approved by your broker or the association, but you are strictly forbidden from drafting original legal language from scratch. Drafting unusual or highly specific provisions often requires legal expertise that resides outside the scope of a real estate license. If you attempt to draft provisions that carry deep legal weight, you are technically acting as an attorney without a license, which is a violation of state law and can lead to severe disciplinary action by the Georgia Real Estate Commission. Your duty is to act as a facilitator of the transaction, and when clients demand language that is overly complex or specialized, the correct professional move is to refer them to legal counsel. By maintaining this boundary, you not only protect yourself from litigation, but also ensure that your clients receive binding, professional advice tailored to their specific legal needs. See you in our next session. Welcome to our exploration of property identification, where we will master the precise language of land ownership as required by Georgia law. This chapter is designed to ensure you can navigate the technical complexities of legal descriptions with the confidence needed to pass your board exam. In the state of Georgia, a valid legal description must be sufficient to locate a parcel of land with absolute certainty. While casual observers might rely on street addresses, these are insufficient for legal conveyance because they are informal and subject to change. A proper legal description must rely on survey-based methods that leave no room for ambiguity regarding the boundaries. We focus primarily on the meets and bounds system, which acts as the foundational method for identifying property lines by identifying a point of beginning and following a series of courses and distances. This is a technical process that requires careful attention to detail, as any deviation in the stated direction or length can render a contract unenforceable or, worse, create a title defect. The meets and bounds method relies on monuments, which are physical markers used to define the boundaries of a property. These monuments can be natural, such as a large oak tree or a creek bed, or artificial, such as an iron stake driven into the ground or a concrete marker set by a licensed surveyor. In modern practice, we prefer artificial monuments because they are less prone to movement than natural ones, though historical descriptions often reference both. When reading these descriptions, you will encounter the term courses, which refers to the direction of a boundary line, usually expressed in degrees, minutes, and seconds relative to a compass bearing. The distance, or the length of that line, is typically measured in feet, and precision here is the bedrock of conveyancing risk management. Beyond meets and bounds, Georgia property is often identified through the recorded plat map system, which is sometimes referred to as the lot and block system. This method is predominantly used in residential subdivisions where a large tract of land has been surveyed, subdivided into smaller lots, and recorded in the county land records office. When a developer creates a subdivision, they file a plat map that shows the layout of all lots, streets, and easements within that tract. In a real estate contract, referencing the specific lot number, block letter, and the recorded plat book and page number effectively incorporates the full technical survey by reference. This simplifies the conveyancing process significantly because it avoids the need to transcribe a complex string of compass bearings into every single purchase agreement. Georgia's history of land division imparts a unique layer of complexity that you must understand to place a parcel within the state's geographic framework. The state is divided into land districts and sections, a system that dates back to the original land lotteries conducted by the state government to distribute territory. When identifying rural land or acreage, a legal description often includes the land lot number, the district, and the section. This hierarchical system acts like an index for the property, ensuring that there is no confusion between two similarly named areas in different parts of the state. If you're reviewing a legal description on the exam, always check for these identifiers, as they provide the essential context for the specific coordinates or plat map being used. For a survey to be acceptable at a closing, it must meet specific standards set forth by the state and the requirements of the lending institution. A survey conveys not only the boundaries of the land, but also the location of all improvements, such as houses, garages, and sheds, relative to those boundaries. It also identifies any encroachments, where an improvement from a neighboring property crosses onto the subject property, or vice versa. An accurate survey minimizes the risk of title disputes, which are among the most common and difficult problems a real estate professional may encounter. Always verify that a recent survey has been performed, as outdated surveys may fail to account for new additions or shifts in boundary markers that occurred after the original map was drawn. Errors in these descriptions are not merely clerical inconveniences. They can cloud a title for decades and cause massive litigation risks for the involved parties. If a mistake exists in the deed, it may fail to transfer the intended parcel, leaving the new owner in a state of legal limbo. When drafting or reviewing these documents, you must ensure the starting point is clearly stated and that all courses and distances create a closed loop. We refer to this as a closing the loop, meaning that the measurement of the boundary lines must return exactly to the place of beginning. If the math does not result in a closed loop, the description is considered defective and is insufficient for a valid title transfer under Georgia law. See you in the next session. Welcome back. Today we are delving into the mechanics of earnest money and the legal landscape surrounding contract defaults in Georgia. Earnest money functions as a demonstration of good faith by the buyer, signaling a serious intent to fulfill the obligations outlined in the purchase agreement. Under Georgia law and the standard GR contract forms, the broker acting as the holder of these funds occupies a fiduciary role, often described as a stakeholder. This means the broker does not have an ownership interest in the money, but instead maintains it in a designated escrow account until the transaction reaches a conclusion. It is crucial to remember that the broker is strictly regulated by the Georgia Real Estate Commission regarding the timing and documentation of these deposits. When an offer is accepted, the funds must be deposited within the time frame specified in the contract, typically 3 business days, unless the agreement dictates otherwise. The broker must document every movement of these funds, ensuring that the paper trail is transparent and fully compliant with state license laws. Failing to manage these funds correctly exposes the broker to significant regulatory risk, which is why your understanding of trust account management is non-negotiable. Disputes frequently arise when a transaction does not reach the closing table, triggering the need for a formal resolution process regarding the earnest money. If the parties cannot reach a mutual agreement on the disbursement of funds, Georgia law provides the mechanism of interpleader. This process allows the broker, as the stakeholder, to file a legal action to turn the funds over to a court. Once the interpleader is initiated, the court takes over the responsibility of determining which party is entitled to the money, removing the broker from the liability of making unilateral decision. The documentation required for this process is extensive, as the court will scrutinize the contract, the sequence of events, and the specific reasons for the default. Brokers should avoid the temptation to guess the outcome or favor one client over another, as this violates their duty of neutrality. Following the strict procedural requirements of the interpleader process is your safest path when consensus between the buyer and seller fails. When analyzing contract defaults, we must distinguish between liquidated damages and penalties, as the legal distinction is quite clear in our jurisdiction. A liquidated damages clause is a predetermined amount that the parties agree will be paid if the buyer fails to perform, serving as the seller's exclusive remedy. In Georgia, these damages must be a reasonable estimate of the potential losses incurred by the seller rather than a punishment for the defaulting party. A provision that acts as a penalty, intended to coerce performance by imposing excessive costs, is typically unenforceable in a court of law. Therefore, when you are reviewing contracts, ensure that the damages stipulated are tied directly to the loss of time and the costs of taking the property off the market. If a contract is silent on these remedies, the injured party must pursue other legal avenues, which are often slower and more expensive. Understanding this balance is essential for drafting agreements that are both firm and legally sound. In the event of a breach, specific performance stands out as an equitable remedy that allows one party to force the other to complete the transaction as originally agreed. This is most commonly sought by the buyer if the seller decides to withdraw after entering a valid binding contract. Unlike a claim for monetary damages, specific performance requests that the court command the seller to convey the property title. Because real estate is viewed legally as unique, courts are generally amenable to this remedy, provided that the contract is clear and the buyer has fully performed their side of the obligations. However, this is a heavy-handed measure, and plaintiffs must demonstrate that their intent was genuine and that they were prepared to execute the purchase at the time of the breach. You should recognize that while this is a powerful tool, it often involves protracted litigation, significantly delaying the ability of either party to move on to other agreements. The time of essence clause is arguably one of the most critical elements in a Georgia real estate contract, as it elevates the importance of every stated deadline. When this clause is present, time is not merely a preference. It is a rigid condition of the contract that renders failure to meet a date a material breach. If a buyer misses a due diligence period or a financing contingency deadline, the seller may have the right to declare the contract in default immediately. This eliminates the wiggle room that might otherwise be afforded in general contract law, where reasonable delays are sometimes tolerated. As a licensee, you must track these dates with extreme precision, as a single missed deadline can jeopardize the entire deal and result in the forfeiture of earnest money. Professional practice requires that you maintain a calendar of all critical milestones to ensure that your client is never caught in a position of technical default. See you in the next lecture. Welcome to this chapter on contingencies and special stipulations, where we will examine the precise mechanisms that protect parties in a Georgia real estate transaction. We will dissect how these clauses function within the broader framework of contract law to ensure your success on the state exam. When we approach the topic of contingencies, we are essentially looking at conditions that must be satisfied or waived for a contract to move toward closing. In the Georgia real estate market, standard GR forms incorporate several critical contingencies, such as financing, appraisal, and inspection. Think of a financing contingency as an escape hatch that allows a buyer to withdraw without penalty if they fail to secure a loan under specific terms within a defined window. The appraisal contingency serves a similar purpose, protecting the buyer if the property valuation comes in lower than the purchase price, potentially leaving a gap between the loan amount and the required cash to close. It is essential to understand that these are not merely suggestions, but are binding contractual rights that dictate the timeline of the entire transaction. Failure to adhere strictly to the dates and periods specified in these contingencies often results in the waiver of those rights, which can significantly jeopardize the buyer's earnest money. When you draft or review these, you are managing risk for your client, and any ambiguity in your language can create immense legal liability. Precision is not an option. It is a fundamental requirement of the practice. Due diligence periods represent one of the most significant aspects of Georgia purchase agreements, providing the buyer with a specific window to evaluate the property. During this period, the buyer reserves the right to terminate the contract for any reason or no reason at all, provided they deliver notice within the agreed time frame. This is a powerful, yet strictly time-bound, tool that shifts the leverage during the contract phase. You must distinguish this from specific inspection contingencies, where the buyer might only have the right to request repairs based on a professional report. If the buyer decides to proceed after the due diligence period expires, they are effectively moving toward a binding purchase, often losing the right to terminate for general property condition issues. Sellers, in turn, are looking for certainty, so they will closely watch these dates to ensure the buyer is not using this time to tie up the property without intent to close. As a professional, you are responsible for keeping these dates on the radar for your clients, as a missed deadline can be interpreted differently depending on the specific stipulations drafted in the agreement. Special stipulations often arise when the parties want to modify the standard terms found in the pre-printed contract forms. These could involve specific home warranty requirements, seller concessions for closing costs, or unique agreements regarding post-closing occupancy. When drafting these, you must rely on clear and unambiguous language to avoid interpretations that diverge from the party's intent. For example, when specifying seller concessions, you should be precise about whether the amount is a fixed dollar figure or a percentage, as this impacts the lender's loan-to-value calculations. If you are handling repair requests, the stipulation must indicate exactly who is responsible for the work and, ideally, what standard of quality is expected for those repairs. Georgia law and the Georgia Real Estate Commission emphasize that these additions must not create conflicts with the primary contract. If a special stipulation is poorly written, it risks creating a meeting of the minds issue, which is the foundational bedrock required for any enforceable contract in the state. Always test your wording by asking whether a neutral third party would reach the same conclusion regarding the party's obligations. The legal implications of failing to meet contingency deadlines are profound, as the contract usually proceeds to a state where the buyer is locked in. If a buyer misses an appraisal contingency deadline, they may be forced to choose between closing the deal at a higher out-of-pocket cost or defaulting on the contract. Defaulting is the worst-case scenario, as it typically leads to the forfeiture of the earnest money, which is legally defined as the remedy for the seller's lost time and market opportunity. To avoid this, you must understand the process of formal termination, which requires precise notification to the opposing party. You cannot simply walk away or stop responding to emails. You must follow the contract's instruction on how notices are delivered to be effective. In the context of a state exam, you will be tested on your ability to recognize these scenarios and identify the correct procedure for maintaining the status of the earnest money. Always remember that the contract's language is the final authority, superseding verbal agreements or loose understandings that might occur during the heat of negotiations. See you in the next lecture. Welcome back. Today we are starting a critical chapter on contract disclosures and how they specifically apply to Georgia real estate transactions. We will focus on the mandatory federal and state requirements that keep both the buyer and seller legally protected. In Georgia, the foundation of every purchase agreement rests on full disclosure of a property's health and physical condition. When dealing with residential structures built before 1978, federal law mandates the lead-based paint disclosure. As a licensee, you must understand that this is not merely a formality, but a strict requirement to provide the buyer with any known records or reports regarding the presence of lead. The seller must provide an EPA-approved pamphlet on lead hazards, and the buyer must be given a 10-day period to conduct an inspection or risk assessment. Failing to include this disclosure, or worse, failing to provide the accompanying documentation, exposes the seller and the broker to significant legal liability and potential federal fines. You are essentially acting as the compliance buffer here, ensuring that every form of notice is signed, dated, and attached as an exhibit to the primary sales contract. Moving beyond federal mandates, Georgia law places a heavy emphasis on the seller's property disclosure statement. While the state does not strictly require a seller to disclose every minor quirk of a house, the duty to disclose known material defects is absolute. If a seller is aware of a leaky roof, a failing foundation, or past water intrusion, they have a legal obligation to inform the buyer. Many sellers attempt to circumvent this by listing a property as sold in as-is condition. It is a common misconception that as-is provides a total shield against liability. In reality, an as-is clause does not protect a seller against fraudulent concealment or the intentional hiding of material facts that would not be apparent to a prudent buyer during a routine inspection. Your role as a licensee involves guiding the seller toward full honesty because silence on known defects is a fast track to a lawsuit. Specific environmental and safety concerns require further attention, particularly regarding the Georgia Department of Natural Resources guidelines. When a property contains underground storage tanks, hazardous materials, or identifies threats like radon, mold, or persistent pest infestations, these must be addressed through proper disclosure forms. Radon, being a colorless and odorless radioactive gas, is a silent hazard that many buyers might overlook. Yet in certain regions of Georgia, it is a significant concern. Mold, often resulting from moisture issues, also triggers the need for documentation to satisfy the duty of care. Brokers are tasked with ensuring that these specific addenda are correctly incorporated into the purchase agreement as exhibits. If these documents are missing or improperly executed, the integrity of the entire contract can be called into question, as the buyer may later claim the purchase was executed based on incomplete information. The broker's responsibility is effectively to ensure that the chain of disclosure is unbroken from the initial listing to the closing table. You're not expected to be a home inspector or an environmental scientist, but you are expected to be the gatekeeper of transparency. This means verifying that the seller has completed their declarations accurately and that the buyer has acknowledged receipt of these disclosures in writing. Every exhibit attached to the Georgia Association of Realtors forms serves as a legal anchor for the deal. By managing these disclosures with methodical care, you prevent the misunderstandings that often lead to breach contracts. Remember that the goal is to create a reliable and enforceable contract where both parties enter the final stages of the transaction with their eyes wide open to the property's realities. I will see you in the next lecture. Hello there. Let us look into the nuances of leasing and landlord-tenant relations within the state of Georgia. This session will ground your understanding of how leasehold estates are formed and the specific legal frameworks that govern the interaction between property owners and their occupants. In Georgia, the creation of a leasehold estate requires a clear understanding of the statute of frauds. While the law permits oral leases for a term of 1 year or less, any lease agreement exceeding 1 year must be in writing to be legally enforceable. This requirement serves as a protective measure to ensure that both the lessor and the lessee have a documented record of the terms, especially concerning the duration and obligations of the tenancy. When a lease is written, it should clearly state the names of the parties, a precise description of the property, the amount of rent, and the specific duration of the occupancy. If the lease is for more than 1 year, the signature of the party to be charged is essential. Failing to reduce an agreement for a term over a year into writing often results in the creation of a tenancy at will by operation of law. Understanding this distinction is fundamental when evaluating the validity of a contract during your exam. Regarding the termination of these arrangements, the law provides distinct notice periods based on the type of tenancy. A tenancy at will occurs when there is no fixed term, and the law specifies that a landlord must provide 60 days of notice to terminate the tenancy. Conversely, the tenant is required to provide 30 days of notice to the landlord when they intend to vacate the premises. A tenancy at sufferance or holdover tenancy arises when a tenant stays in the property after the expiration of the lease without the landlord's consent. In this scenario, the landlord has the authority to initiate eviction proceedings or treat the tenant as a trespasser. Dealing with these tenancies requires precise adherence to the timeline set by Georgia statutes to avoid procedural errors. These rules prevent arbitrary evictions and provide a predictable framework for ending a professional relationship between owner and occupant. Security deposits remain a highly regulated aspect of the landlord-tenant relationship, as they are essentially held in trust for the tenant. Georgia law implies that these funds must be managed with transparency to ensure they are returned unless specific conditions for retention are met. If a landlord holds security deposits in a single account, they generally do not have to pay interest to the tenant unless the lease agreement explicitly mandates such an arrangement. However, Brokers acting as property managers are strictly governed by Georgia Real Estate Commission rules regarding trust accounts. If a property manager receives a security deposit, it must be deposited into a designated brokerage trust account within 3 business days, unless the lease contract specifies another timeline or the broker has a written agreement to the contrary. Following these custodial rules is non-negotiable, and any commingling of personal funds with these deposits is a severe violation of commission standards. The eviction process in Georgia is governed by the writ of possession, which is the legal mechanism used to regain control of a property. This process begins when a landlord makes a demand for possession after an event of default, such as failure to pay rent. If the tenant fails to comply, the landlord must file a dispossessory affidavit with the appropriate court to initiate the formal process. A summons is then served to the tenant, who has 7 days to file an answer to the court. If the court rules in favor of a landlord, a writ of possession may be issued, allowing a sheriff to physically remove the tenant and restore possession to the landlord. This process is the only legal way for a landlord to effectuate an eviction in Georgia, as self-help evictions, such as changing locks or cutting off utilities, are strictly prohibited under state law. Tenants in Georgia also benefit from the implied warranty of habitability and the doctrine of constructive eviction. Even in the absence of an explicit provision in the lease, a landlord is obligated to keep the premises in a state of repair that fits it for the purpose for which it was rented. If a landlord fails to remedy conditions that render the property uninhabitable, a tenant might argue constructive eviction, which allows them to terminate the lease and move out without further liability. Furthermore, while the repair and deduct remedy is limited in many jurisdictions, Georgia tenants must follow very specific procedures before attempting such actions. It generally requires clear communication and documentation of the defects to the landlord, followed by a reasonable period for them to address the issue. Being aware of these protections helps resolve disputes before they escalate to litigation or formal legal intervention. Property management is a major responsibility that falls under the purview of a real estate broker. When a broker manages property, they're legally acting as an agent for the owner, and they must disclose this relationship to any parties they interact with during the course of business. A broker must represent the owner's interests while maintaining the fiduciary obligations required by the brokerage engagement contract. This includes the responsible management of funds, the regular inspection of the property, and the accurate reporting of income and expenses. Because the broker is handling someone else's assets, they must adhere to the highest standard of professional ethics. Any failure to disclose the management role or any mismanagement of funds, particularly within a trust account, will result in disciplinary action from the Georgia Real Estate Commission. See you in the next lecture. Welcome to our deep dive into Georgia mortgage instruments and the unique mechanics of the security deed. In this chapter, we will master the technical nuances of how Georgia secures real estate debt and the specific legal instruments that make this state's lending landscape distinct from the rest of the country. When navigating real estate finance in Georgia, you must immediately set aside your intuition regarding traditional mortgages or trust deeds, as the state operates primarily through the use of a security deed, often referred to as a deed to secure debt. In most other jurisdictions, a borrower might sign a mortgage that creates a lien on the property, but in Georgia, the transaction functions quite differently under the law. When a buyer signs a security deed, they are technically conveying legal title to the lender for the specific purpose of securing the underlying debt. Despite this conveyance of legal title to the lender, the borrower retains what we call equitable title, which grants them the full right to possession and use of the property as long as they adhere to the terms of the promissory note. This is a critical distinction to grasp because it defines the foundational relationship between the lending institution and the homeowner throughout the life of the loan. It effectively means that the lender holds the title as a form of collateral, rather than simply holding a lien that must be foreclosed upon through a court of law. This unique arrangement is the engine that drives Georgia's streamlined approach to property finance and eventual debt satisfaction. If you're preparing for the state board exam, you must remember that the security deed is the primary instrument that distinguishes Georgia from title theory or lien theory states in their traditional, simplified forms. Understanding this structure prevents confusion when you encounter questions regarding who actually holds the title to a property during the amortization period. While the security deed functions as the instrument of conveyance, the promissory note serves as the personal promise from the borrower to repay the debt according to the agreed-upon interest rate and schedule. Embedded within these documents, you will almost certainly find an acceleration clause, which acts as a protective tool for the lender in the event of a default. If a borrower fails to meet their obligations, such as missing payments or failing to maintain insurance, the lender may invoke this clause to demand immediate payment of the entire remaining balance of the loan. This is the mechanism that triggers the path toward foreclosure, as it terminates the borrower's right to continue paying in monthly installments. Crucially, the security deed typically includes a power of sale clause, which is the cornerstone of Georgia's non-judicial foreclosure process. Because the lender holds legal title, they are empowered to conduct an auction to sell the property without filing a lawsuit in a superior court, provided they follow the strict statutory notice requirements. This is why non-judicial foreclosure is significantly faster and more cost-effective in Georgia compared to states that require formal judicial intervention. As a practitioner, you should understand that this efficiency is precisely what keeps credit affordable for borrowers in the state, even though it shifts a heavy burden of compliance onto the lender. Beyond the mechanics of the loan itself, the process of clearing such a lien requires careful adherence to Georgia's recordation statutes. Once a borrower fully satisfies their obligation under the promissory note, the lender is legally required to execute a cancellation or a quitclaim deed to reconvey the legal title back to the borrower, effectively clearing the cloud on the title. In practice, this is handled through the recording of a satisfaction of the security deed in the county records where the property is located. If a lender fails to do this after the debt is satisfied, they can be held liable for damages, which highlights the importance of the paper trail in real property law. Furthermore, we must address the risk of deficiency judgments, which arise if the proceeds from a foreclosure sale are insufficient to cover the total amount of the debt plus costs. Under Georgia law, the lender has the legal right to pursue the borrower for the difference, but they must strictly follow the procedural rules regarding confirmed sale filings to maintain this right. If the lender fails to obtain judicial confirmation of the foreclosure sale price being fair and reasonable, they may lose their right to seek a personal deficiency judgment against the borrower. This balance between the lender's right to recover their capital and the borrower's protections against unfair valuation is a core component of the state's regulatory framework. Mastering these procedural nuances ensures you remain competent when explaining the life cycle of a loan to your future clients. See you in the next lecture. Hello and welcome back. Today, we turn our attention to the mechanics of non-judicial foreclosure in Georgia and the specific rights associated with property redemption. In Georgia, the foreclosure process is predominantly non-judicial, meaning it does not require a court order to proceed as long as the security deed contains a power of sale clause. This clause grants the lender or the trustee the authority to sell the property upon a default by the borrower. Because this process happens outside of the courtroom, strict adherence to statutory procedures is required to ensure the sale is valid and enforceable. The trustee must act within the specific scope of the authority granted by the security deed and the requirements set forth in the official code of Georgia annotated. If any step in the process is missed, the title transfer can be challenged, which makes understanding these technical requirements essential for any real estate professional. You should view the power of sale not just as a contract provision, but as a rigid set of instructions that must be followed to the letter to avoid legal complications. One of the most critical components of the Georgia non-judicial foreclosure process is the notification requirement. The lender must provide proper notice of the time, place, and terms of the sale to the borrower. This notice is not merely a formality, but a legal necessity that must be delivered to the borrower in accordance with state law. Furthermore, the lender is required to advertise the foreclosure sale in the legal organ of the county where the property is located. This advertising must run for 4 consecutive weeks prior to the date of the auction. The goal of these requirements is to provide transparency and ensure that the public is aware of the impending sale, which potentially increases the chances of a fair market bid. If the lender fails to advertise correctly or provide the required notice to the borrower, the entire foreclosure process can be rendered void, leading to significant delays and legal liability. A distinct feature of the real estate landscape in Georgia is the absence of a statutory right of redemption after the foreclosure sale is completed. In many other jurisdictions, borrowers are granted a period after the auction to pay off the debt and reclaim the property, but Georgia law does not offer this protection to the defaulting borrower. Once the hammer falls at the foreclosure auction and the deed is delivered, the sale is considered absolute and binding. This makes the bidding process and the surrounding legal procedures particularly high stakes for all parties involved. While the borrower can potentially pay off the loan and halt the process at any time before the sale is finalized, they lose their opportunity to redeem the property once the title is transferred. Understanding this finality is crucial because it differentiates Georgia from states that prioritize post-sale redemption, directly impacting how investors and lenders approach distressed properties. While foreclosure is a common mechanism for dealing with default, alternatives such as short sales and deeds in lieu of foreclosure play a vital role in property resolution. A short sale occurs when the lender agrees to accept a purchase price that is less than the total balance of the mortgage. A deed in lieu of foreclosure involves the borrower voluntarily transferring the title to the lender to satisfy the debt without going through the formal foreclosure process. Both options are generally preferred by lenders because they are less expensive and less time-consuming than the full foreclosure process. However, these arrangements are still subject to approval by the lender and can be influenced by the presence of junior liens or specific bankruptcy filings. Bankruptcy, in particular, invokes an automatic stay that can pause or stop foreclosure proceedings under federal jurisdiction, requiring careful navigation of both state laws and federal bankruptcy regulations to proceed. See you in the next lecture. Welcome back. In this lecture, we will dissect the legal mechanisms of title transfer, specifically focusing on the hierarchy of deeds and the strict formal requirements for a valid conveyance under Georgia law. A deed is essentially the vehicle through which legal title and real property moves from a grantor to a grantee, and understanding its integrity is fundamental to your professional practice. In Georgia, the deed must contain specific elements to be legally effective between the parties, starting with a competent grantor and an identifiable grantee. You must ensure there is a clear statement of consideration, which is the value given in exchange for the property, even if that amount is nominal. The legal description of the property is perhaps the most critical component, as it must be precise enough to distinguish the subject parcel from all others in the county. Without a sufficient legal description, the instrument fails to provide certainty, which could lead to severe title defects that remain hidden until a future sale. Furthermore, the deed must express the intent to convey, often evidenced by operative words like grant, bargain, and sell. Finally, the conveyance is only complete upon the delivery of the deed by the grantor and the acceptance of it by the designated grantee. When we examine the types of deeds available in Georgia, the general warranty deed stands as the gold standard for the grantee because it provides the most comprehensive protection. This deed includes 5 foundational covenants, starting with the covenant of season, where the grantor guarantees they own the property and have the right to convey it. The grantor also covenants against encumbrances, promising the title is free from any hidden liens or easements not mentioned in the deed. The covenant of quiet enjoyment ensures the grantee will not be disturbed by any third party asserting a superior title claim. Additionally, the grantor provides a covenant of further assurance, promising to perform any additional acts necessary to perfect the title if a defect is found. Finally, the warranty of title is a promise that the grantor will defend the grantee against all lawful claims existing from the beginning of the world until the current moment. In contrast, the limited warranty deed, sometimes referred to as a special warranty deed, offers significantly less protection to the recipient. This instrument restricts the warranty of title to the period during which the grantor actually owned the property. The grantor guarantees that no title issues were created while they held the title, but they take absolutely no responsibility for defects arising from earlier owners. This is common in transactions involving foreclosures or estate sales, where the grantor has limited personal knowledge of the property's history. You will also encounter the quitclaim deed, which serves as a release rather than a guarantee of ownership interest. This deed conveys only the interest the grantor currently holds, if any, and carries no warranties regarding the quality or existence of title. It is frequently used to clear clouds on a title, such as resolving a disputed boundary or formalizing a divorce settlement. Specific circumstances call for specialized instruments, such as the administrator deed, which is used when a court-appointed individual conveys property on behalf of an estate. Because an administrator is acting under the authority of a probate court, they cannot offer the same warranties as a private seller. The conveyance is limited to the interest of the deceased individual, and the deed serves as proof that all procedural requirements of the probate code were followed. Regardless of the type of deed, the formalities required for recording are non-negotiable under Georgia law. To provide constructive notice to the world that you are the equitable owner, the deed must be filed at the county clerk's office. Constructive notice is a legal fiction that presumes the public knows about your ownership because it is part of the recorded public record. For a deed to be eligible for recording, Georgia law mandates strict witness requirements that you must verify before leaving the closing table. The document must be signed by the grantor in the presence of at least one unofficial witness and one official witness, who must be a notary public. The notary public performs the function of verifying the identity of the signer and witnessing the act of signature to prevent fraudulent transfers. This dual witness requirement is a safeguard intended to maintain the integrity of our land record system. If you fail to ensure these signatures are present, the county clerk will reject the recording, leaving your client without the protections afforded by public recordation. Recording protects the grantee against subsequent purchasers who might otherwise take title without knowledge of an earlier, unrecorded transfer. The bundle of rights is the conceptual framework we use to describe what is actually being transferred during this process. When a deed is delivered and accepted, the grantor is effectively transferring their rights to possess, use, enjoy, exclude, and dispose of the property. If the grantor attempts to transfer rights they do not possess, or if the deed is defective, the bundle is effectively severed or clouded. Your role as a licensee is to ensure that the document accurately reflects the intention of the parties and complies with all localized recording statutes. A valid deed serves as the final, absolute evidence of the transfer that the courts rely upon in property disputes. Mastery of these requirements is essential for protecting the interests of your clients throughout the life cycle of the transaction. I will see you in the next lecture. Welcome back. In this lesson, we will deconstruct the specific tax obligations and closing cost arithmetic mandated by Georgia law to ensure you can confidently navigate the financial disclosures on your state board exam. When we approach the financial side of a real estate closing in Georgia, we must first address the state-specific transfer tax. This is essentially a tax paid to the clerk of the Superior Court for the privilege of transferring title to real property. The calculation is straightforward if you apply the rate of $1 for every $1,000 of the sales price, or any fraction thereof. If the sale price is not an even multiple of 1,000, you must round up to the nearest $100 increment to determine the taxable amount, and then apply the 10-cent increment rule per $100. For example, if you have a property selling for $200,000, you're looking at a base transfer tax of $200. It is a common trap on exams to forget that the transfer tax is typically paid by the seller unless the parties have specifically negotiated a different arrangement in the purchase agreement. Always check the contract terms carefully, as the state provides the requirement for payment but allows contractual flexibility for shifting this burden. Next, we move to the intangible recording tax, which is a state-level requirement specific to new long-term real estate loans. Unlike the transfer tax that deals with the conveyance of the deed, the intangible tax is tied to the security deed recorded against the property. The rate is set at $1.50 for every $500 of the new long-term debt. A crucial detail to remember is that this tax is only calculated on the amount of the new loan, not the total purchase price of the property. If a buyer is assuming an existing mortgage, the intangible tax is generally not applicable, or it involves different calculations depending on the remaining balance. You must verify if the math requires you to divide the loan amount by 500 and then multiply by the rate of $1.5 to reach the final tax liability. This specific fee is usually the responsibility of the buyer, as it arises exclusively from their choice to secure new financing for the transaction. Beyond these state taxes, you will encounter the necessity of prorations, which ensure that both the buyer and seller pay their fair share of recurring expenses based on the exact day of closing. Property taxes, interest on existing debt, and utility payments must all be allocated proportionally to the time each party held the property during the current tax or billing cycle. In Georgia, a statutory year is often calculated using 360 days for the sake of simplicity in arithmetic, though you should rely on the specific instructions provided in an exam question. When dealing with prepaid items like annual property taxes, the seller is typically given a credit for the period remaining after the closing date. Conversely, if a tax bill is paid in arrears, the seller is debited for the time they own the home, and the buyer receives a credit to cover that portion of the bill when it eventually comes due. These calculations require precise accounting to ensure the closing disclosure accurately reflects the final cash-to-close figures for both sides. We must also acknowledge the administrative requirement that all real estate closings in Georgia occur under the supervision of a licensed attorney. Because the state maintains a firm stance on the unauthorized practice of law, legal professionals are the only ones permitted to oversee the transfer of deeds and the disbursement of funds. This means your closing costs will inevitably include attorney fees, which often incorporate title examination, document preparation, and the settlement meeting itself. You will often see exam problems asking for the net-to-seller calculation, where you subtract the brokerage commission, the transfer tax, the existing mortgage balance, and the attorney fees from the gross sales price. Similarly, a buyer cash needed calculation requires adding the down payment, the intangible tax, prepaid interest, and shared closing costs to reach the total investment required. These arithmetic tasks are designed to test your attention to detail regarding who pays for which specific cost item. See you in the next lecture. Welcome back. In this lesson, we will examine the mechanics of Georgia property taxation and the hierarchical nature of liens that affect real estate titles. Property taxation in Georgia is based on the ad valorem principle, which literally means according to value. The foundation of this system rests on the assessment of property at 40% of its fair market value, a figure determined by the county tax assessor. It is crucial to internalize that this 40% calculation represents the assessed value, which serves as the tax base rather than the raw market price. County assessors utilize standardized mass appraisal techniques to estimate the worth of properties within their jurisdictions on an annual or cyclical basis. Once this value is established, tax commissioners apply the millage rate to determine the actual tax bill. Taxpayers maintain the right to appeal these assessments if they believe the valuation does not accurately reflect market conditions or contains factual errors. These appeals must follow strict statutory timelines, typically requiring action within a set window after the assessment notice is received. Failure to meet these deadlines effectively waives the right to contest the property's tax assessment for that specific year. Distinguishing between general taxes and special assessments is essential for accurate financial planning in a real estate transaction. General ad valorem taxes fund the ongoing operations of local government, schools, and infrastructure through revenue collected from all property owners based on their assessed values. Special assessments, by contrast, are specific charges levied against properties that receive a direct, measurable benefit from a public improvement, such as the installation of sidewalks, sewer lines, or street lighting in a particular neighborhood. Unlike general taxes, which are perpetual in nature, special assessments are typically finite, lasting only until the cost of the improvement has been fully amortized by the affected owners. Because these assessments attach to the property, they can create significant encumbrances that a professional must identify during the title examination process. Understanding whether an outstanding balance is a general tax or a special assessment dictates how they are prorated at closing. Georgia provides a mechanism for relief through the homestead exemption, which can significantly reduce the tax burden for primary residents. To qualify, an individual must own and occupy the property as their legal residence as of January 1st of the application year. This exemption is not automatic and requires property owners to file an application with the county tax office by established deadlines, which usually fall on or before April 1st. Once granted, the exemption acts as a partial shield against the total assessed value, effectively shielding a portion of the property from the millage rate applied by local taxing authorities. There are additional exemptions available for seniors, veterans, and individuals with disabilities, each carrying its own specific eligibility requirements and documentation standards. Savvy practitioners ensure their clients are aware of these filing deadlines, as missing them means losing the financial benefit of the exemption for the entire tax cycle. The priority of liens is a fundamental concept for ensuring clear title, especially when multiple interests are encumbered against a property. In Georgia, property tax liens hold a super priority status, meaning they take precedence over almost all other financial claims against the property, including previously recorded mortgages. Mechanics liens, which arise from unpaid labor or materials provided to improve the property, gain priority based on the date the work commenced, provided the lien is filed within the statutory period. Judgment liens, resulting from court-ordered financial settlements, attached to the property as a record of debt, but generally rank behind tax liens and pre-existing security deeds. When a title search reveals a tax FIFA, which is the legal document representing a tax execution, the property owner is effectively prohibited from conveying clear title until the specific debt is satisfied and canceled of record. Title insurance providers will almost always require the payoff and formal release of these liens before issuing a policy, as they represent a definitive liability. If a taxpayer fails to satisfy their obligation, the property may be sold at a tax sale to recover the unpaid ad valorem taxes through a process involving a tax FIFA. Following such a sale, the state provides a redemption period during which the original owner may reclaim the property by paying the winning bid amount, plus statutory interest and applicable penalties. This period is a protective measure designed to prevent the permanent loss of ownership due to administrative errors or temporary financial hardship. During the redemption window, the purchaser at the tax sale holds a conditional interest in the property rather than full, marketable title. Only once the redemption period expires without a claim from the original owner can the tax sale purchaser seek to quiet the title and solidify their ownership interest. Real estate professionals must understand these timelines to advise clients accurately on the risks and potential recovery methods associated with tax-encumbered properties. I will see you in the next lecture. Welcome to our deep dive into the intricacies of title insurance and the mechanisms of recordation within Georgia. We will examine how professional verification secures ownership rights against potential legal challenges. In Georgia, the validity of a property transfer relies heavily on the principle of public recordation, which serves as the bedrock of real estate ownership. When you record a deed or a security instrument in the office of the clerk of the Superior Court, you are effectively providing constructive notice to the world of your interest in that property. This act is essential because it establishes priority, meaning that subsequent purchasers or creditors are legally expected to know about your recorded interest. Without this formal record, a buyer might inadvertently purchase a property burdened by undisclosed liens or adverse claims, leading to significant financial liability. The system relies on the assumption that if an interest is not recorded, it does not exist in the eyes of a bona fide purchaser. Consequently, the act of recording protects both the owner and the lender by creating a clear, chronological history of ownership and encumbrances. Understanding this process is not merely an administrative detail, but a core component of risk management in every successful real estate transaction. To ensure that the chain of title is clean, a thorough title search is conducted using the indexes located in the Superior Court, the General Execution Docket, and the Record of Deeds. This search is designed to uncover any discrepancies, such as unpaid taxes, mechanics liens, or outstanding judgments that could potentially cloud the title. In Georgia, we rely on attorneys to synthesize these findings and provide an opinion on the insurability of the title before the closing date. The title insurance commitment is the product of this research, acting as a contract agreement to issue a policy that guards against hidden defects. Owners' policies and lenders' policies offer different tiers of protection, with the lender's policy typically covering only the amount of the mortgage loan. The commitment allows the parties to address any identified issues, such as obtaining a release of a lien, before final funds are exchanged. This professional review process acts as the ultimate safeguard against the financial ramifications of a defective title. When a title is burdened by ancient claims or unresolved legal disputes, the process of a quiet title action becomes necessary to gain a clear, marketable title. These legal proceedings are designed to purge the record of outdated or invalid claims that might otherwise impede a future sale. Georgia statutes, particularly those related to the Marketable Title Act, provide a mechanism to limit the duration of claims, effectively cutting off rights that have not been asserted within a specific time frame. This legal framework is vital for commerce, as it prevents properties from being indefinitely sidelined by dormant or frivolous claims from decades past. Through a quiet title action, a judge issues a decree that settles the ownership status, providing the insurance company with the certainty required to extend coverage. Once the court validates the title, it becomes marketable, meaning it is reasonably free from doubt and can be transferred without the risk of future litigation. This transition from a clouded title to a marketable one is a fundamental service that attorneys provide to facilitate the alienability of land. The interplay between recorded documents and unrecorded interests creates a complex landscape that requires careful attention to state and federal case law. Constructive notice is provided by the public record, but actual notice, where a party is aware of an unrecorded interest, can create binding obligations that standard records might miss. Georgia law generally favors parties who record their interests, yet equitable doctrines exist to protect those who might be unfairly prejudiced by a lack of notice. For instance, if a tenant has an unrecorded lease that is clearly visible to a potential buyer, the buyer may be held to have inquiry notice of that lease. This is why the attorney's search results must go beyond merely checking the automated indexes. They must account for the physical state of the property and the rights of those in possession. Failing to account for these nuances exposes the insurance company to claims that could have been identified through diligent investigation. We rely on the synergy between precise recordation and a comprehensive attorney search to maintain the reliability of the Georgia real estate market. I will see you in our next lecture. Welcome back. In this final session, We will synthesize everything we have covered into a cohesive framework to ensure your success on the Georgia Real Estate Board exam. When we approach the final review, it is helpful to view the material not as disparate chapters, but as an interconnected ecosystem of obligations under the Georgia Real Estate Commission and the Brokerage Relationships in Real Estate Transactions Act. You have spent significant time learning about trust account compliance, the minutiae of legal descriptions, and the strict boundaries of fair housing. But the exam expects you to wield these concepts simultaneously. Consider how a brokerage engagement is intrinsically tied to the way you handle earnest money, or how a failure in disclosure during a transaction can unravel the legal protections afforded by your license. By structuring your memory around statutory duties rather than random facts, you create a mental hierarchy that allows for faster retrieval during the high-pressure environment of the testing center. Most candidates fail when they try to compartmentalize, so focus instead on how the legislation, the contract forms, and the ethical rules form a single, consistent standard of practice for a Georgia licensee. Strategy on the exam requires a deliberate approach to the simulation-style questions that define the current Georgia assessment. Unlike straightforward definition recall, these questions often present a complex scenario involving a client relationship or a trust account discrepancy, forcing you to identify the primary legal breach first. When reading these, ignore the emotional fluff injected into the prompt and isolate the statutory requirement. Ask yourself which specific GREC rule or BRRETA provision is being tested before you even glance at the multiple choice options. Often, the exam uses distractors that sound legally plausible but contradict Georgia-specific agency definitions, particularly concerning ministerial acts or the transition between a client and a customer. Remain mindful that the Georgia Real Estate Commission prioritizes consumer protection above all else. So when in doubt, choose the answer that most strictly aligns with the fiduciary obligations established by law. Regarding high-weightage areas, the data consistently suggests that mastery of BRRETA, trust account compliance, and the intricacies of GR form disclosures are the primary differentiators between a passing and a failing score. Candidates frequently stumble on the technicalities of designated agency versus dual agency, likely because the distinction requires precise adherence to written consent requirements that are non-negotiable under Georgia law. Furthermore, ensure you are absolutely comfortable with the calculation-heavy aspects of closing costs and property taxes, as these questions are designed to test your ability to apply mathematics in a professional context. Do not ignore the procedural rules regarding advertising, as these are often tested as negative questions, where you must identify the prohibited action in a list of otherwise standard practices. Avoiding common pitfalls means reading every word of the question stem rather than skimming for keywords that might trigger a pattern of answering based on intuition rather than statute. Success also hinges on your command of the logistics involved in the examination process through the PSI testing provider. Verify your eligibility status in the portal well before your exam date, and ensure that your identification documents strictly match the name on your registration, as any discrepancy here is a frequent and entirely preventable cause for rejection at the test center. Review the specific protocol for the non-judicial foreclosure rules and the specifics of the Georgia security deed, as the mechanics of the state-specific finance section can be quite jarring if you have treated it as an afterthought. Arrive at your testing facility with the understanding that these procedural details are just as much a part of your professional readiness as the legal knowledge itself. Managing your exam day environment, including your time allocation per question to ensure you do not get stuck on single, complex problems, provides the mental space necessary to demonstrate your competence. Approach the exam with the confidence that you have covered the necessary statutory landscape to operate legally and effectively within Georgia. You now possess the tools to navigate the regulatory framework, the commitment to transparency required by the Commission, and the strategic clarity to excel under pressure. See you at the test center.